guess we'll go ahead and get started in the interest of time, and if they trickle in, then just join our meeting. So we'll go ahead and call this meeting to order. I've got 1:02 p.m. and we'll do a roll call of the members.
Constable Sean Kennington,
I'm online.
thank you. Chief Mike Harmon,
Present.
Judge Stephen Abels, Chief Robert Crawford,
Present online.
thank you. Curtis Howard,
Present.
Kevin Lawrence,
Saw where he's under the weather. He's,
Yeah. Thank you.
Bob Leonard,
Present.
Lieutenant Lizette Rivera, present. Dr. Jonathan Scheinberg,
I'm here online.
thank you. Dr. Stephen Tate,
I am here.
Clay Taylor,
Here.
Sheriff John Wayne Valdez.
Here.
Thank you.
Well, welcome everybody for our second meeting, and getting through the weather coming here. There's a little bit of traffic coming all the way down from Cedar Park. Long drive and commute, but glad we're all here together today. Did everybody have a chance to look at the minutes from our previous meeting? If we had anybody had any questions, talk through those or anything? Good to move forward, approve the minutes of the meeting from October 11th.
I make motion.
I second. Second. All right, all in favor of approving the minutes of the meeting from October 11th, say aye.
Aye.
Any opposed? All right, we'll approve the minutes from October 11th, 2023 Advisory Committee meeting. Next, discuss and take action on matters relating to developing a model policy prescribing standards and procedures for the medical and psychological examination of new licensing, existing licensees, and those who employing agencies has reason to believe a new examination is necessary as established under Texas Occupation Code 1701.167. So,
Well, I want to say, hey, thank you, Chief. Thank you for everybody for being here. Weather's turning on us a little bit, so it's you never know in Central Texas. Thank you for everybody online. I'm John Beecham, Interim Executive Director and General Counsel for the agency. If we haven't had a chance to introduce ourselves before, today's discussion and moving forward, Director Grissom will be leading discussion as we walk through both the substantive and the procedural information that we have in order to kind of get the discussion started today. Cullen?
Good afternoon, ladies and gentlemen. One of the things that we had hoped from the last meeting is that we might get some model policies from agencies. We as staff have not received any input on that. I don't know, I communicated with the presiding officer and assistant presiding officer is when last I heard from them. Neither of them had received some model policies. So did anybody bring a model policy?
So I brought one as well. Ours mirrors civil service a lot because we're the 143 city, so. Sure. There's not really a whole lot that's different than that.
Well, and I think it's important that any model policy we adopt is gonna have to harmonize with that statute anyway, so it's going to have that look to it, one way or the other. You said you did bring a copy?
I did. A lot of ours is definitions and then again refers to chapter 143, but I also brought that 143.081. If anybody wants to look at it, see.
We
We can make some copies.
make copies of that.
I'll make sure it's that.
Thank you, sir.
Probably just these 2 pages.
You got
Kind
it.
of ours and
You got it.
Yeah.
Fantastic.
Okay.
Sorry.
Yeah.
You want to go through
Do that next?
Yeah.
Okay.
we can do that. One of the things, Aaron Heath, the Assistant General Counsel, kind of came up with if you look at this as a two-part process, there's the process that occurs at the agency, and that's kind of the policy component, and then what happens to it when it gets reported to us. And I think what Aaron's done with this kind of flow chart is try and parse out what the statute says is going to happen post, once TCOL gets notified either of general, in this case, a refusal. You've requested of an employee has refused to do it, you've notified TCOL as required under the statute.
That's right. It kind of puts in chronological order the statute, which isn't necessarily in chronological order. So the general flow chart, here are the things that happen, and then we'll go through the process here. In these circles right here with the white background, these are some of the things that you had mentioned in the previous meeting as items to be discussed and to be determined for the model policy or for any potential rules that TCOL may adopt as part of this review. And so you can see, and this is specifically for the fit for duty. So this is already an appointed licensee right here, not necessarily for the hiring purposes. That's a good clarification right there. So this is one of the things that you will be determining is when that examination is required. Moving on, so once a determination has been made that the examination is required, you have to provide the written notice. And as the statute says, the written notice has to include the reasons for the examination, which that'll go in part with what triggers the examination, obviously. And then the written notice must be provided not later than the 10th business day before the deadline to submit to the examination. We had some discussion about this last meeting, and that prompted some of this right here. Extending notice more than the 10 business days. If there's a deadline given, can that licensee request an extension? And there are certain situations where there might be different lengths for the notice. That was part of the discussion last time. And then it gets down to here, which control for this.
If you
Oh, it's right- oh.
the touchpad on.
Just right here? Okay.
Here, are you trying to go down?
Yes.
There you go.
Okay. Great. You go up a little bit.
You did that.
Little bit.
Yeah.
That's the.
Let me see if I can
Sorry.
do it a little.
That's the only two.
Okay.
movements I can do.
Kind of moving down here. This is one of the areas where there's a divergence here. Did the licensee submit to the requested examination? So we have the yes and the no track. And so the no track is the refusal track that we talked about a good deal at the last meeting with some of the potential items to discuss. It's a lot simpler on the yes, they submitted to the examination. And did they pass? Process complete? No. We talked about if they fail the examination and then some of these applicable treatment programs, what is a reasonable time to complete? And then also an issue is how long does the employing agency have to report a failure to TCOL? Because that's one of the requirements. So that's something to be determined. And then go down a little. Down a little bit. So if they fail the examination, the statute says TCOL shall suspend that licensee. Going back over to the refusal track over here, which is, I think that's an orange color. Yes. Okay, so once they refuse and the deadline is passed, the employing agency has to report to TCOL that refusal to submit to the examination. The question is, how long do they have to report it? Just like over here, how long does the agency have to report a failed examination? How long do they have to report a refusal to submit to the examination? And then it gets kind of into the process here that's at TCOL down here. So once we get this notification, this report that there's been a refusal, we'll issue an order, show cause for the refusal at a hearing scheduled for not later than the 30th day. We're currently in the works on this process with SOA as to how it's gonna play out, but right now, the thinking is that SOA is gonna be the fact finder in these situations, and then SOA is gonna issue a proposal for decision. That proposal for decision will go to Texas Commission on Law Enforcement, our commission, for a final order. So that will that takes care of the rest of the process here. But we're kind of ironing out the details right now with SOA as to how that's gonna go. And the final order, so this is what we talked about. The commission will issue an order requiring the licensee to either submit to the examination or withdraw the request for the examination. And so I suppose there might be some discussion as to how that withdraw the request process will go. Because I guess it will be reported back to the agency to withdraw the request. And then depending if the order says that they have to submit to the examination, TCOL may suspend or otherwise restrict a licensee who continues to refuse to submit to the examination. So we've got this kind of in order with some of the issues to be discussed notated here. Does anyone have any questions? Sure.
I don't know if this is so much a question, but just something to talk through that we ran into several years ago, and we had worked through it through our meet and confer contract with our association. But when we go back up to the notice, extending notice more than 10 days, questions in there. Let's say an agency has an employee, a current employee, and the chief orders a fit for duty, whether it's psychological or a physical. The following day, that employee comes in with FMLA paperwork and says, I'm going out on FMLA for 12 weeks. What do? You still continue through the process, or you have to wait out the 12 weeks until that employee comes back to pick up the process and then continue to move forward with this?
The way I understand all this is that this doesn't interfere with the agency's ability to address problems within their own agency. This is just when you get to the point where you order them and refuse, that now there's an additional track that will be pursued by TCOL. So that would still be within the realm of your decision as the employer within your policy. In other words, if you want to allow him to go on FMLA, and that doesn't pose a risk under his license, right? He doesn't need to be fit for duty, and once that's resolved, then you would evaluate him at that time. I don't think that changes that. It's just once you order him and he refuses, that's when it triggers the action where TCOL becomes involved.
Okay.
And even where he talked about the withdrawal, I think when we get to that, even if TCOL decided to withdraw, I don't think that requires the agency to withdraw. It just means that we can't compel them under our portion of that responsibility. But I don't think it takes any authority away from the chief administrator in dealing with an employee under his agency policy, under your municipality or county policies or anything else.
Chief, to ask a question for maybe clarification for myself, so what you're saying is you give an employee their notice of fitness for duty psychological exam. and the very next day they show up and say, I'm going out on FMLA. They've got their documentation, their doctor's notes, everything else. City approves it, they're out.
Right.
Are you asking that while they're out on FMLA, can you order them or compel them to do something while they're out on FMLA?
Right, that's my question is because the scenario was years ago when we had an employee get put under an internal affairs investigation, it literally happened like they came in and said, oh, guess what? My doctor's putting me out on FMLA for 12 weeks. Well, you know, we have 180 days, so we were on the clock and had to wait all that out. We weren't able to do anything with them because we were out on FMLA for 12 weeks.
Right.
And so my question is, do we still continue through this process even though they're out? Contacting them on while they're on FMLA is a little iffy, you know, as well. So,
Yeah, I would agree with TJ's assessment is that's all on your side of the wall. So, I think you would end up sorting that at the agency without TCOL being a player to that.
because if I'm needing something from them while they're out, like we really can't contact them, say, hey, I need you to come back in because of whatever, right?
I'll
So-
give you the extreme example of a pregnant female officer who is now on bed rest from her doctor due to a complicated pregnancy. I hate to be the chief that orders her in and something
Right.
happens.
Yeah,
I would
exactly.
imagine to avoid any liability, even if we believe that they're making it up, it would be best as an agency not to force them and just to wait for them to finish their time, and then if they come back, proceed with the process, I would imagine.
And if they go out on FML, it may be because of whatever issue that we're dealing with here. That may potentially resolve itself as they come back.
Well, and I think if you attempted to compel it on the front end, you say, okay, this has to happen. They go out on FMLA, you can always withdraw that for that duration and then reissue it when they want to come back to work. Because I think the primary driver behind this is what citizens' welfare. Is this person able to do the job? Is this person mentally, emotionally fit to do the job? If they're on FMLA and not doing the job, then I think that whole thing stalls. If you as the chief, you know, when they want to come back to work, you can have the determination, are these things still true? And start the process at that point, to include 10 days notice or, you know, whatever the applicable notice is. I think John distributed the.
I hate to regress. Can I back up one more prior to that?
Sure.
Last time we met, when a request is submitted for an examination by the agency, does the employee have the right to choose their own doctor to evaluate?
If, under 143, the first examination is the employee's.
First, right?
So if we're gonna harmonize the 143 with the model policy, then we could say the employee will choose their psychiatrist, psychologist, physician first.
Because that, I was contacted by, and I'll let you know that your public, notice does work, because somebody called me because they saw that I was on the board. And, their concern was, and they gave me a scenario of one of their employees at the agency, they got a call to the house, person was suicidal, gun to the head, talked them out of that, immediately put them on a fit for duty evaluation. That individual and got the evaluation came back, yes, needed whatever the recommendation was. That employee then quit, went down the street, literally to the next agency. They got a call about it. They asked this individual to go get an examination. That individual picked out their own doc, got a notice that said perfectly fine. And that person is now working for that agency.
This process would have addressed that when they separated from the first agency.
Okay, that's-
though.
yeah, that's
When
what I
they
was-
refused to get treatment, that's what would have triggered the license action and suspending the license that prevents any other agency from having that opportunity.
Okay.
That's the tool that's been added, is we now have some responsibility and authority once they refuse.
That's what that's,
I have a question though, and I guess I'll throw it out here and we can address it when it's appropriate later, but we're talking about homogenizing the T-Cole rules with 143. 143 provides for an appeals process that at-will employment does not. First of all, most agencies that are not 143 will send officers or deputies to their doctor of their choice. And I've got a file full of problems with that. But on top of that, if the department head, the Civil Service Commission and others don't agree with what the officer brings back, in your example, they have a right to then send the officer out for their own evaluation. And then, as you all know, you get the panel of 3 through the Civil Service Commission to review everything and make a determination. Are we going to provide the officers and deputies an opportunity to appeal before their licenses get suspended, revoked, or?
And Bob, I think you're speaking specifically to non-civil service entities,
Yes.
correct?
Yeah.
I think that's certainly a policy decision that's in a discussion that's in front of this committee, yes.
Because I'd certainly hate to, we have a large portion of officers who are protected under civil service. Even deputies in some counties have either 158 or
Sure.
countywide civil service that provides them some remedy. But the vast majority, overwhelming majority of officers in the state are at will, have no protection like that. And I think that if we're talking about revoking or suspending their licenses, that they should be entitled to some due process somewhere.
Well, I think it's certainly a good discussion point because it will have to be addressed whether it remains as is or there is that appeals process built in, or it could accommodate the appeals process, meaning any license action, the first step of what we're discussing here, the procedure, which that's downstream from the standards for which the fit for duty is made a determination on, right? What appeals are going to be, is the model policy going to reflect? Obviously, civil service, if it's somewhere in statute, we can't override that. That's not going to be infringed upon, nor should it, obviously. The next question is, if there are appeals available, which in some places we know they're not, is the committee going to mirror those which exist in other civil service or other statutory appellate right jurisdictions?
I just want to get it out there because the example that was just given, I think kind of got me to thinking about, where we need to be come March, so.
Absolutely.
Who would they appeal that to?
I think that's an internal local appeal. If that's my understanding with the conversation where that discussion point we're at, it's my understanding the civil service and Cullen, I don't want to step on your toes here, but there's internal appeals in a civil service entity prior to it triggering the refusals. Is that correct? Okay.
Yeah, because we have a commission, a civil service commission, and those who are not, do they just appeal it to the?
Certainly, yeah, I don't think this would override or short circuit any of those existing appeal processes right now, local appeal process, absolutely not. This is only after those have been exhausted, certainly my reading of it.
I see that in the flow chart, there is an opportunity, the third pink box down where it says, at the hearing, the licensee may present evidence to justify their refusal to submit to the application, to the examination. However, it doesn't say that they get the opportunity to refute the examination. In other words, they do submit and they fail. but they've got their own physician who, or psychologist who determines that they are fit. And now there doesn't seem to be a place for them to appeal that.
So that would be them taking the examination. So
Yes.
that would go on the other track on the left side instead of going down the right,
Right.
which is the orange side. So
But it says that if the licensee fails the examination in the
Yeah.
first peach colored box,
right,
that the only remedy there if they fail is that they have to submit to an applicable treatment program, rather than being able to appeal or refute that they failed.
so I think that can be interpreted that that is a final failure, and so the appeals process has been exhausted to that point there. That blue area, I guess, would encompass the whole process. Did the licensee pass the requested examination? So that would encompass all of the potential appeals.
And that's where I'm going with this, is that as we've talked about the 143 cities, 158, and county civil service personnel may have the opportunity to appeal. 143 of course does, and 158 and countywide civil service may have the right to appeal. But for the vast majority of officers throughout the state, they don't have the right to appeal. They're one and done. And that's the problem that I'm foreseeing if we're gonna be taking licenses. And
Sure.
you know, I'm trying to put a mechanism in place that prevents us from litigating all of these people who are gonna be, cause at some point, we're gonna have to file lawsuits for due process. That you're taking my right to work and I didn't get due process. So,
I think part of this and there was a lot of discussion of this as the lawmaking was going on, is if this becomes the state's model policy and it has to harmonize with 143, you're gonna be driving at-will employers to a lot more 143 based processes. So if the state's model policy says chief administrator requires an employee to do one of these, and to be in line with 143, the model policy says the employee gets to go to their physician, psychiatrist, or psychologist, like 143 says, so that's gonna be the first determination. Now, you still have the chief, sheriff, or constable can say, I don't like the outcome, now you're going to go to mine. Okay, but I think this, remember, every agency in the state has to adopt either this model policy or something substantially like it. So I think this is kind of driving maybe toward your goal of more protections in an at-will employer. Now, I don't think it's gonna, impose that entirely on them, but I think this model policy, this group has the ability to craft some of those things into that model policy.
my only concern, and I'll leave it at this, cause I think I'm taking up too much time, but this goes to the doctor's point, the last time we met. I've got a client in the Houston area who was ordered to retake a psychological after having been out for an extended period of time. That examination consisted of about 25 minutes on the telephone and was told that they failed. And, we're now fighting that, but the point is that I would hope that the doctor would agree that a 25-minute interview on a telephone to determine whether or not you can work for the rest of your life is to me substandard. But I just think that people should have a right to protect their future, their family's future, with some mechanism in place if we're gonna provide the taking of their license, that, they should be able to say, hey, we'll wait, I've gotten at least a fair shot at protecting my license.
I think it's important, you're saying take licensing for the rest of their life, but it does use the word shall suspend and not shall revoke. So
Well,
it does indicate that there is some possibility that they could restore their license at some point.
yeah,
I think it still
and
needs to be determined,
but for the most part, when your license is taken and all you're doing is for the majority of your life as law enforcement, it's very difficult to transition to some other field you know, while your life is, you know, you've got your mortgage, your life is going, plus that's pretty hard to overcome when you have to tell employers, hey, look, you know, they basically told me I was psychologically unfit to be a police officer. Well, who's hiring you? That's our concern.
No, and understanding, and I just make this statement, and all those are good points in the discussion so far. There's no limit to the due process that can be put in here by the committee. That's certainly, there's no quota or limitation on how much you all want to see fit to be put in here. So I just want to throw that out there.
So it could even be as far as, just like we were saying, if the agency's test failed, the employee's test pass, does that mean this can go so far as we have to have a odd man wins? Get another one, or the agency?
Civil service,
I
you
mean,
do, you have a panel of three.
Right.
Positions.
we don't have,
Right, that's what I think we're trying to get at is
Yes.
those who are not under
and if so, if we,
one forty-three.
if we all have to adopt this model policy, those of us that are not civil service, are we going to have to also now create this panel from our community or from the county judge, or, I mean, how far are we willing to take this?
The Civil Service Commission appoints 3 people, so our commission does it. So if you have a regulatory body like a council or the commissioners court as part of this process, that would probably
Well,
most
the panel of
likely.
3 is usually doctors.
Yeah.
They
It has to be
review the
psychiatrists,
reports
this-
from
yeah.
the other doctors, the competing doctors, but
Right, but they're appointed by the commission.
We don't have three.
But the only thing I can say to the sheriff's point is that for those cities that aren't 143, your employees are at will. And if they're not a good fit for you, then, you know, they're basically showing the door. And if I'm getting the feel for the room, at some point, we're gonna be talking about whether or not every time you apply for a new agency, you're going to be required to take a psychological exam. So if somebody is released at will, at some point, they're gonna have to be retested in order to be able to be rehired, so.
I did have a clarification, a question, and it kind of goes to what Mr. Taylor brought up, and that is with once a determination is made for fitness for duty for an officer, one of the issues that has come up, well, for our agency, they have to have, I think they have to have 2 out of 3 passes in order to, you know, get through this. One small question I have about this, maybe it's not a small question, but is there any mandate within the state of Texas that says that the employee has to pay for this, or the agency is required to pay for that, or that has not been determined? That's one question I had.
I'll defer to the panel or the committee and see if they have any examples from their jurisdiction.
Most of the people that we deal with go through their health insurance. Especially if they're seeing a treating doctor for issues, either physical or mental, they're already, you know, because when it says you will go to your own doctor, usually there's somebody who's treating you. So it's been handled by insurance.
So in other words, they are responsible for covering that, not the agency who's ordering them to have the fitness for duty. That's what you're finding?
If the county, the groups that I have that are not civil service, the groups that force you to go to their doctor, the counties have been paying for that.
Okay.
So if they force you to go to their doctor, they've been paying.
The first one's.
That's how it works.
First one, you go to your doctor.
Yeah.
If the city or county doesn't like it and wants you to have a second one, then the governmental entity will pay. At least that's the way we do it in Plano.
Yeah, same thing.
So the other kind of larger issue that we've come across is the qualifications of the examiner. That is just a hot mess. And I hope that we're able to iron something out there, because, you know, I know I'm kind of biased as a clinical psychologist versus a medical doctor. And a medical doctor who has not had any law enforcement exposure at all or is culturally competent, or a clinical psychologist who is competent doing an evaluation, but they're not culturally competent with the law enforcement community.
It was almost exactly the scenario I was given, was that this individual went to a well-known doctor that everybody knew. Doctor was 80-something years old. And that individual wrote that this person was competent to return to work.
So may I jump in here for a moment? It's John Scheinberg speaking. Can you all hear me?
Yes,
Sure.
So it's I've been sitting here in the background hearing you all speak, and the thing that comes through my mind, again, I'm not a psychologist, but as a physician, I can tell you that when we see these forms, these L2s that come through, you have to understand what ends up happening is if you put yourself in a physician standpoint where you have 30 people to see in an afternoon, this person comes in, you do your quick exam on them, then they present you this form. The physical exam checkbox is really an afterthought. These people are not getting really thorough analyses. They're not being evaluated as to what would be a potential stressor. So the question really is, and I would agree, but yet phrase it a little bit differently. The question is, how do we handle the expertise of the evaluator and phrase it as, do we just simply, is this black box acceptable? I know this is a huge can of worms, but does TCOL need to provide a more detailed analysis of what would be required for this individual, for that physician or that practitioner to sign off? Because the way it is right now, it's a very rudimentary, let's check the box. That could be anything. And quite frankly, most of the physicians who look at this are overworked. They don't have the time to put this in. However, if I had a list of things, can this person run, a train for a 2-mile run? Are they able to do pull-ups or the list is almost infinite. But if there was more guidelines, we could simply close that box. Now, I can't speak on the psychological evaluation of what that would entail because that's outside of my specialty, but I would imagine the same kind of information would hold true in that regard, that there needs to be more specific analysis so you don't have, to use the example, someone who's really retired just checking the boxes and these people are getting through without a thorough evaluation. That would be my only feedback at this point.
Well, this is exactly why I'm bringing this up, is that there's no standardized framework, I don't think, for each doctor or individual that's doing these examinations to know what does it mean to actually perform a fitness for duty. And to me, it seems like this is the perfect committee to begin to iron that out, put that out there to make it fair across the board so that you're really doing due justice for that employee, that officer, and for the public. There's people that spend, most of their professional life understanding just what fitness for duty means and how to do that. Some people write, 10, 15, 20 pages. They do, 2 to 4 hours of testing for one individual. And they gather background information, they gather disciplinary stuff from the agency. The agency, I would say, and again, I throw this out there, should be required to give information as to what led to them to state they are not fit for duty, or there's concern about that at least. Not just, we believe this person's not fit for duty, but not give a list of what led to this and stuff that entailed, so that they have a fair look at what's going on with this individual, why did this happen, and then let me administer my tests for this. But again, no disrespect towards any physician here, but most medical doctors that I know, even psychiatrists that I know, they've not been trained to properly administer the type of tests that you would administer for fitness for duty. And if they're not doing
I agree 100%. You're absolutely right. And that's where the huge breakdown occurs because we all assume that that one box solves the problem.
Yeah.
But if they check that box, the majority of the people are not getting the thorough evaluation that they probably should have.
And then if that is the case, then a medical doctor that received that kind of information and realized, okay, T-Call is requiring X, Y, and Z. Yes, the agency is requiring this fitness for duty, but the agency is trying to follow the guidelines of the state agency, so to speak, T-Call. And this is what's required. You're gonna have medical doctors say, oh, hold on, I am not competent to really do this, I would think, if you're gonna be honest. So then that leads me to my other question, is which is what we're struggling with at HPD, is having a list of qualified examiners that we can use to give to our employees who are asked to do a fitness for duty. Their officers, they don't know who to go to. They're struggling with trying to find someone. So they may find someone that's favorable, but they have no qualifications to do what they're asked to do. And that's not fair to anyone. They may even get a favorable response, but it's not really thoroughly looking at it.
So the only physicians that are really trained to do that kind of evaluation are physical medicine rehabilitation, PMR doctors. And they're far and few between, and you'll never find a group of them. I think it's much easier just to come up with a list of criteria.
Yeah.
What does it mean to be fit for duty? From a physical standpoint, you need to be able to do these 10 things. Boom, put them on paper. This way, any doctor can look at it and say, I think you can do this. You can have an internal medicine or a family practice doctor or an OB-GYN look at this and go, oh yeah, you can run, you can lift, you can carry, you can drag, you can climb, you can wear a vest, you can be exposed to stressful situations. That's easy. But in limiting the practitioners who can do it, I think that's going to be more trouble than it's worth, because I can tell you here in Austin, I can't even, and I've been practicing in Austin for 20 years, I can't even give you the one name of a physical medicine and rehabilitation doctor. I don't even know one. So those are the only people who are really trained to do it, and I think that's a can of worms you don't want to open. But I think just making a list of the criteria, which we can potentially agree on rather easily, would be a much better way to handle that.
You look at how many agencies in the state of Texas, mainly the small ones, even do a fitness test for an applicant. You see what I'm saying? And you brought up a great point. So then T-Code, we come up in this committee with that physical test, like the doctor's talking about, but then how far do we take this? Do we mandate it to where they have to retake that test after an injury or after a certain amount of time? Or do we use the military test, basically, which is push-ups, set-ups, vertical leap, 300-meter dash, and a mile and a half? But the older you get, the less push-ups and set-ups you have to do, and the more time you get for those runs.
Right, but there's a difference between a physical fitness assessment and a
Right.
fitness for duty assessment.
Correct.
So I would, that's a whole other ball game, and I do agree we probably should have state standards for physical fitness assessment, but I don't think that's a huge thing to attack. But I think we can come up with a very simple list of criteria that any physician or nurse practitioner or PA can easily evaluate someone and say this person is able to complete or do these 10 or 11 or 5 things that we've all decided upon. We're talking about just basic stuff, and especially if someone's going to be entering a training academy where they're going to be improving in their fitness assessment, it's a different story. But if we have a very good baseline, because clearly if someone has, a knee that won't bend, clearly I can say, well, this person probably can't run 3 miles. It's an easy thing. If I have someone who's got a history of heart failure, I can say this person's probably not going to be able to do these things. But that can be done by any type of physician or provider. So I think, to answer the question, I think the fitness standard should be kept separate from the fitness for duty standard.
Hey, Doc, this is Cullen Grissom. I've got a question for you on
Yes, sir.
the physicals as you describe it. Is there a model or standard out there? But what comes to mind is a DOT compliant physical for commercial vehicle operation. Is there a standard that you know of that could be easily adopted? And the reason I ask is anytime we increase those things, we limit the providers, and that's the big fear in rural law enforcement. So if we were to say only people with credential X can do either a physical or a psychological, then access to those people, we generally have about plus or minus 15,000 licensees a year that need these events. And so, but is there a pre-existing, pre-employment style, lift 50 pounds, move here, do this? Is there a pre-existing standard that we could point to?
That's a great question, and I know the answer is possibly, and it would be published by the American College of Occupational and Environmental Medicine. They have specific guidelines for law enforcement. The guidelines that I am intimately familiar with are guidelines we adhere to after an injury or illness. But I'm going to look to see if they have. I can easily take that under my wing and under my auspices and look at that, and I can search to find out what the American College of Occupational Environmental Medicine has for the development of a police training program and what is basic requirements to do so. So I'm sure it's out there. I don't know it off the top of my head, but let me do some looking, and I'm happy to kind of report back to the committee next time with that information.
And one of the things, to this doctor's point, I would be willing to research the possibility of some guidelines of, what to follow when a person is gonna do a fitness for duty evaluation, at least so that we have something. For example, I just looking up Dr. David Corey. He's, this guy is astute with doing fitness for duty evaluations. He may already have something out there that could be helpful for a state agency like this. And with this kind of question, I don't know. But something is better than nothing. Not that we had, sugarcoat or water down what's necessary. But I think that for every examiner that's out there, we don't know what they're doing. I don't know what they're doing. What criteria are they using to make an evaluation? And if everyone has to do at least these things, it kind of cringes on my heart as a psychologist say, follow these 10 steps and everything's gonna be fine. But at least if you have some guidelines that they have to follow, then at least it gives you some chance to know that there's a standard that's out there that the state has looked at and is requiring for every examiner to follow. And to your point, I forget your name.
Cullen?
Yes.
Cullen?
Cullen, yes, thank you. Yeah, having a list of, of people that are fully qualified, that would be awesome, but wow, I don't know how we're able to do that.
That we run into very shaky ground when the state says this group of people can do something.
Right.
And people with the appropriate license in the eyes of the state, we exclude them. And so it is better to, at least in my mind, and John and Eric can jump in, give us what anybody with the appropriate license, because that's the way the state's gonna look at it. You're licensed to do this job.
Right.
So how do we arm somebody who may not do these all the time with enough information? And I sounds like it gives you brain damage, but those steps, these are the tests, these are the steps. We can be more prescriptive about the process than we can about who can do it.
Correct.
Right, I agree.
And that's a good point on a lot of, I think it's been a great discussion the last 10 or 15 minutes. So, and I think we have some good examples when we talk about the standards, which is clearly within this committee's, the protocol to come up. What are the standards and procedures for fit for duty? And I think we've got a couple examples to at least get us headed in a direction here today in your handouts. And we should have some queued up here as well. I think we had one from DPS and we had one from Cedar Park as well. And I think Cullen has a model policy that we can take a look at for discussion's sake. And I also want to give a reminder in the discussion about who can do this and who can do the examination. A big driver behind that is simply, I'm going to read some statistics off. And this is always, and that's why this committee is composed the way it is. But it's something we always, as an agency, and obviously the regulated community knows this as well. But agency types in the state, to give you the types, we've got over 800 municipal agencies, goes all the way down to a couple of railroad police agencies. And we were talking about what are the size of these departments? So why does it matter who's doing these examinations? Well, size of departments, I'm looking at it here. We have, what's the percentage overall? That's we have 25, 30, 60, almost 60 some odd percent that are 10 or less officers. And they're throughout the state, obviously, far west Texas, deep east Texas, in the valley, et cetera. So we are talking about accessibility, availability, who can do these things. Obviously, if everyone could have a three-person panel as according to civil service, that would be fantastic. That's simply not either the way it's set up or just the resources aren't there. But the good news is we have a great opportunity here to equalize that as much as we can. Just like we've done in the past, when I say we, the regulated community, TICO, the legislature, everybody, secure share system, things like that, background investigations, making more information available to hiring agencies than there's ever been. Where in the past, it was just like, well, I can't get it, can't make the decision or make a bad decision in hiring someone. We're at the same crossroads here with the fit for duty standards. So that being said, it's always good to remember in context, there are many more small agencies than there are larger agencies. So let's just keep it in context with those resources available. And I think maybe the principle that in the committees and as well as anything, as we all well know, striving for perfection is certainly can be very closely done, but it takes a whole lot to get there. And maybe the juice is not worth the squeeze at the end, given where we have to go and the timeline we have to go. And keep in mind, we always have room for improvement down the road as well. Because as it stands right there, now there is no fit for duty review process in the state of Texas. So any movement you make as a committee, that will be a step in the right direction.
John, if I may just say two things.
Sure.
One, most of your large city departments have a fitness for duty prior to even joining the department. There's a physical that you have to pass, and there's Cooper's test and all these other things. However, I don't want to get to the point where an officer who has 17 years in the department breaks their ankle, and then I just want to know that their ankle is okay and that the ankle is not prohibiting them from being a police officer anymore, and put them back to work. They shouldn't have to go through an entire entry-level fitness test in order to be able to come back to duty. Additionally, I think that the concern that I have is that if we're going to set the standards to a point where, you know, officers have to worry about the possibility of mid-career being told, well, now all of a sudden you're not eligible anymore. As you pointed out, Doctor, in the first one, in your experience, you've seen officers with 15 or 20 years who are scarred or, you know, I mean, a lifetime of experiences. But that doesn't mean that they can't be good police officers. So I don't want to set a standard or a bar so high that, you know, we're now impeding on departments from being able to keep good officers because the state has set an example, a level or a standard that, you know, is insurmountable for especially older officers. I've got officers in my big cities departments, Austin, San Antonio, Fort Worth, and I'm sure you probably have some in Houston that are 62 years old and on patrol. I'm sure that they can't pass the same exams that a 22-year-old can pass. And as to the sheriff's point about military standards, lowering the standards, you know, accordingly to age, I still think that there's a risk when in the military, you're up every morning at the crack of dawn doing PT, and you're being forced by your employer to maintain a level of fitness that police departments are not. So I think we have to balance out the reality of the world we live in. You know, we can't, as you put it, make a standard so high. There's no such thing as perfection. It's what we can live with. I just want to avoid us trying to set a standard that we have these you know, Roman centurion, you know, myths of the gods type of standards that we're just never gonna find, that we can't hire enough officers to meet the needs today. I mean, if we set a bar so high that we can't get over it, we're gonna be in real trouble. Before I also forget, John, we had talked a little bit about HIPAA problems. I found an AG's opinion that talks a lot about what I think we're kind of discussing. I can either just tell you what the AG's opinion number was, or if you wanna make copies of it, we can do that, but it's from February 13th, 2004. It is Open Records Decision number 681. It was then Attorney General Greg Abbott, now Governor Greg Abbott. It was his office, but it goes into a very, very good explanation about potential issues regarding HIPAA, and how HIPAA itself may not be what we have to be concerned about. There's other state statutes and other things that may prohibit the release of this information, but an agency on its face may be required to release this information, and they have to kind of do a deep dive in order to make sure that they're not violating stuff. So.
Okay, I'd be glad to take a look at that, and we'll send the link that out to everybody. So what we can do is it's an open records decision, open records decision 681, GA 681, I believe. So
Yes.
it's numbered. We'll send a link out to everybody. It's probably the best way to do it. Thank you. Cullen, why don't you, on those lines, I think this would be a good time to maybe discuss the supervisor responsibilities and also the procedures in this demo policy to maybe get the conversation going with, so we have some concrete examples. While these are not definite, these are conversation starters. So Cullen, why don't you take it away?
Yeah, we received this from Lexipol, who does a lot of work with agencies for kind of a holistic policy programming. But in looking at this, I kind of see this as maybe a jump off point for our end goal with the model policy. I think one of the things that we've talked about and we looked at, if you look under the supervisor's responsibility, we need to come up with a model for what triggers these events in the agency. And so, not an exhaustive list, but you know, so if we look at the indicators, this is when, because your first line supervisor should be, in theory, involved in this process of identifying people, because the chief sheriff or constable in even a mid-sized agency doesn't deal with the employees at this level. It's their first line supervisors come in contact with them first, especially if it's a behaviorally, if the request to prove fitness comes from changes in behavior. And so I saw this, we could look at similar or add to this list of things that might trigger internal to the agency. Again, that policy is really hopefully a guide the agency is going to use to shepherd their employees, to regulate their employees' behavior. The state just wants everybody to have a similar policy. So the supervisors, identify it, report it to their appropriate supervisor. It goes up in the agency for duty status. Do we right now take someone off the street? Pending evaluation, pending whatever the rest of the process is, under the duty status. There's a preliminary determination of whether or not the person placed on light duty, taken out of a specific function, or taken out of, an enforcement role altogether. And then it gets down to the fitness for duty exam or evaluations. And this is kind of where we start getting into where we need to be in terms of aligning. This section, you can see it's made to go with 143. It actually references the 143 sections on fitness for duty as you go through process for peace officers. Now, the thing, I think our model has to be more open, so it would probably be processed for employees, because our model policy has to cover all of our licenses, if you will. So if an agency has telecommunicators and jailers and those other licenses, they would need to fall under this policy in the event of, the sheriff's got jailers, so he's gonna, have this apply to them. So it's gonna be broader than just peace officers. I think it's restricted here. The presumption, the way this is written, is this a municipal agency is 143, who's a civil service agency. But I thought that this would maybe give us something to detract from, add to. I think there's some things that are statutorily required that need to go into this policy, such as the once it gets to the point where you have either a refusal or a failure, the agency has an obligation to notify TCOL. That should probably be in the model policy to make sure that, that becomes part of the internal process with the agency. Whatever appeals you see, I think would be built into this. But ultimately, we need to add those statutory tags that if the 10-day, or wherever we arrive with notice, and what constitutes effective notice, potentially a definition of that. That's what we talked about, right?
That's correct.
And then, so I thought maybe we could look at this, or I'll give you an opportunity to read it. For those online, I'll make sure this came to us late. And so I'll make sure and get it out to the other committee members via email. We'll send it out to you.
Have this in the Teams drive.
Is that one of them?
It should be. If not, we can get it. When do you have a clean version of that that's not marked up? There's people online that have to look up Teams chat.
Colin, I'm sending you DPD's Fit for Duty policy.
Okay.
I'm also including IACP guidelines. It also has some really good suggestions there.
Okay. think one of the things, under the process for peace officers section, if you look at that first part, it talks about the initial examination is conducted by the officers, physician, psychiatrist, psychologist. And so that kind of goes to what we were talking about earlier, to where the default is they go to their doctor. Their doctor approves them. They pass or fail at their doctor, if you will. And then the agency evaluates whether they want to accept the pass or fails. It's still a local control. If the sheriff sends somebody, their doc says, yeah, he's great, guy physically can't see or something, and the sheriff says this makes no sense to me, so the sheriff has the option of sending him, or if it's civil service, the commission has the option to send that person onto a second evaluation with a provider of their choosing. And so, but it starts with the individual's choice, goes to the agency choice. And then it does, again, this one is set up for civil service, so it refers to the commission, how we make a generic version of that to where for those agencies, it's a three-person fire marshal's office, that is not civil service, doesn't have any of those. It's a two-man constable's office. That's kind of where the policy needs to impact all of those.
Well, and to that point on page 3, can we have, before this even gets started, with the individual going to their own personal professional, that if there is some type of criteria or guideline that the agencies are required to produce, to be given to that employee, to be given to that doctor of choice, so that the employee and that doctor or whoever it is aware that, oh, there's a grid that needs to be followed, and there's already a built-in level of accountability of what needs to happen, which could include background information that's appropriate, that led to the request for fitness for duty. All that, doesn't have to be exhaustive, but it's fair, hopefully. And that employee realizes that, hey, I'm not gonna try to skirt around this. I really need to look at what led to this in a fair way before they go out to search their own doctor. That's one piece that I have a issue with, is that you can't just go to Joe Blow, and nothing against Joe Blow or Julie Blow, just someone that is aware that, hey, there's some criteria here. I can't just, go on my own expertise as a physician or a psychologist, has no cultural competence with law enforcement personnel. Is that what we can insert in here?
I believe so. I think I think you could put something in that says, that the individual employee identifies the doctor, but that the agency has to communicate to that provider the reasons this employee is being sent. How comprehensive you want to make that language. But if I just go to the doc, say, hey, am I okay? And he's like, yeah, you're fine. And he signs the form.
Yeah, because, let's get real here with that piece. The day that they go to whoever it is, they may be fine, quote unquote, but there's a bunch of stuff that led to them being asked to go. And if you are ignorant of that information, you're only gonna go with what you see and what you have before you. And that's not fair to the employee, even though it may go into their favor. It's not fair to that employee because you're you're not looking at all the factors here.
Looking at the flow chart, second gray box from the top, it says written notice must include the reasons for the examination. I mean, how far in depth are we going on that? It kind of goes to the doctor's point. I mean,
I agree.
that's written notice of why they're sending this person. I mean, but are they gonna then be required to send another document to the doctor once the doctor's been identified? Or is this written notice, which should spell out to the officer or deputy why they're being sent?
Let's use that in conjunction with Cullen. Could you move us towards the supervisor responsibilities on page 1? Let's apply this and.
One moment, okay, that's what that is, okay.
So.
We're also, for the people joining on Teams, we're sharing this on the screen for you guys as well.
Right home. See where we're at? Let's just use this for the sake of an example, hypothetically speaking. An abrupt and negative change in the members' normal behavior. Instead of just pretending we're using this for a second, it's going to go on that fit for duty. You shall get a fit for duty because you've had an abrupt and negative change in the member's normal behavior. That's a conclusory statement, right? It has no, because on January 1st, 2023, you exhibited and said, I'm going to do X, Y, and Z. On January 5th, 2023, you did this. Is that what we're talking about? Sufficient notice to know exactly what behaviors we're talking about here?
Yeah, and I don't know how in depth we're gonna end up going on this, but to take, for an example, a civil service 143 notice of discipline, you have to basically spell out enough in that letter to let the officer know why they're being disciplined.
Sure.
On such and such a date, you did this, which is a policy violation, and that's a checkbox. But yeah, if the officer is to truly know, hey, what did I do wrong? Why is the doctor looking at me?
Mm-hmm.
I didn't know if we were gonna give them a checkbox and then the doctor gets, but the officer should also be entitled to know why or what's the basis of it.
It seems there would be some factual description of the behavior which qualifies for one of these situations. I think that would be within the scope of what we're doing. And my next question is going to be on the civil service example, Cullen. Is that spelled out to how specific those type of determinations need to be made, or is that left to discretion of the department?
I think it's left to the discretion of the department.
Yeah.
It's very-
Not spelled out.
Right.
Okay.
Yeah,
And my point being, I want to make sure we were comporting with civil
yeah,
service law.
it's gonna be, very minimal. I mean, it talks about the report from the physician, but it doesn't necessarily identify information going to.
Yeah.
I don't think there's anything in civil service that bars it.
Oh, of course. I was gonna see if we had an example, a setup that we could follow to, it's already spelled out for
Not
us.
yet, and.
Yeah.
I can ask the doctors who, because you guys have performed fit for duty examinations before. I mean, like, if we had a physical issue, you talk about a broken ankle, I mean, not a huge issue. You probably want somebody to say, hey, he can run on that ankle and do the things that he wants. It doesn't have to do a real in-depth. But what we're gonna do is give the job task analysis, the job description to the doctor. Doctor says, hey, he can do these things based upon that broken ankle or that wrist problem or whatever it is. Not a huge examination, and it wouldn't go very far. It makes it a little more difficult in psychological situations.
Yes.
But a job task analysis or the job description would be the basis that the doctor would get to say, hey, you can perform these functions. So what do you normally see when you do fit for duties for psychological issues?
Well, there has to be a very clear distinction because every agency doesn't operate like this. At HPD, we do not do post-employment fitness for duty evaluations at all. It's only pre-employment.
Okay.
So that's an important distinction. Like New York, from what I understand, New York PD they do both.
Yes.
But-
You can be put off the police department for a failed psychological during your career.
Yeah, from that same person who may have, well, not the same person, but the same division or whatever, who may have given the okay for you to come on board. But at that time, I don't know if it's different now, that same group does not provide treatment while they're employees, like counseling. Because if you're the hiring person and the firing person, you're also providing therapy. There's a conflict of interest. So for pre-employment evaluations, there's criteria that we follow that quite honestly would be similar to what we do if we were to do post-employment evaluations for fitness for duty. We would give similar tests actually and find out where they are. And these 6 things that are here are they're actually pretty good. I mean, they could be elaborated on, but these are pretty good pieces of criteria that could be elaborated on as to what might be problematic. So, you know, a test for pathology is important, and personality, a normal personality. That I would say that's, you know, that TCO requires 2 tests, and one has to be one of pathology. So I would say that would be an important piece, a test for pathology to be done. But then there's questions that could be asked that go into more detail. That's why what Mr. Leonard has said, that you can't do a thorough evaluation in 25 minutes and be effective. Was that you that gave that illustration?
On the phone.
Yeah, I
On the
have
phone,
somebody who had
right.
a 25-minute phone interview and was told they failed.
And told they failed, you know, to do justice to that, you know, just the one evaluation alone might take an hour and a half, you know, for them to fill out, you know, standardized test. I don't know if that, I may be rambling on, but here, but.
Well, I guess my thought is that we are giving these providers some understanding of the reason that the officer is there. And I don't know how you would not do that. And so whether it's the job description, job task analysis, an example of what the behavior was based on these things. So, you know, that notice, then they can certainly do what they need to do and come up with an explanation or a decision as to whether or not that person is fit for duty. Now, we got other questions, I certainly
Well,
understand the
okay,
process, but
so at this point, after you've been hired, would it not be TCO's responsibility to say, hey, we're really glad that you came on board as an officer X amount of years ago. Something occurred now that you've been on board for 5, 10, 15 years, and I'm speaking from a psychological perspective, that cause concern, i.e. these 6, 10, 20 things that we come up with, would it not be reasonable for TCO to say, for psychological fitness for duty, then you have to follow through examiner with another set of standardized tests in addition to a clinical interview. That's what happened with,
Well,
you know.
yeah, I think we
Dr.
could
Busey.
relate it. I think one of the things that might be due the practitioner is what the TCO rules say, or what the statute says about the content of a psychological exam, where you have the, you know, at least 2 instruments, the personality trait and pathology, and a face-to-face interview. Those 3 components have to be present to meet the minimum standards that exist now.
For the post-employment fitness for duty evaluation.
If, in most cases, an agency wants a new L3 form.
Right.
Okay, and for somebody to sign the L3 form, they are saying this has occurred. The 2 scales, that's the intent. mechanically is it happening in the field? I think you've got experience with, you know, or Mr. Leonard, you know, expressed something that probably didn't include all three of those things. And somebody signed off or failed in this case, I guess. You know, so ideally, part of what we might have the agency do in the policy is notify them what constitutes. You know, I think if we come back with the you know, some model for the medical examination, if there's some pre-existing model we can point to, then that would be part of the notice that you had talked about writing into the policy from the agency to the provider.
Right.
Even though the employee is selecting the doctor, the agency has an obligation to notify the doctor the employee is selected to, of these things, the behavior that led to it, you know, the requirement, you know, of the psychological under the statutes as they exist, as the minimum standards. If we have a physical standard to meet, you know, I think those are things, I think both you and the other good doctor both expressed. If we knew what we were measuring for, most doctors would get closer to where we want to be.
I would absolutely agree with that and applaud that approach, because it would level the playing field much more clearly throughout the entire state with following that, at least a reasonable set of criteria for that examiner to follow when they have to do another fitness for duty. And I do think the examiner does sign off on that L3 document for post-employment fitness for duty, but I don't know that they are aware that they still have to follow what the L3 consists of before you sign off on it. If you were to do a pre-employment screening, I mean, this is the first time I've heard of that, because we don't do post-employment fitness for duties. I think if more people knew that, hey, you have to still meet the minimum requirement. Face-to-face, that happens. Testing may, or in some cases may not happen, or they may not be thorough. I mean, there's some other things we could add, like maybe reasonable documents that led to this issue to begin with. You know, when I do in a private practice fitness for duty evaluations for employees, and they give documentation as to what led to them quote unquote getting in trouble in the first place. And that is very helpful. And we have to do, if necessary, a collateral call to a person who knows what happened. I'd love to see that.
So to wrap,
Mr. Leonard may not.
Well, I don't want to make it so, especially for these agencies that have very limited budgets and everything else. You know, we can't make it so that it's counterproductive. I don't want to discourage people who really need help. You tell a chief or a sheriff or constable that this is going to cost them a lot of money, and they're reluctant to send people to do it. So I think that there's a multitude of factors that have to go into it, but I do believe that it has to be comprehensive enough to where the agency is assured that the individual meets their standard, but not so over comprehensive that it's defeating the purpose. There has to be a happy medium somewhere, so I don't agree with the 25-minute phone interview, but I also, know that there's an answer somewhere in between.
I'd agree with that.
so what I'm hearing is want a guidelines or criteria for physical fit for duty and the same for the psychological. Is that correct?
I think that would be,
I think
That's.
I'm here, that's what I'm
Sum
hearing,
it all
chief.
up
That's
and-
what I'm hearing.
Just to be clear that.
You always have the option of subcommittees to do those as well.
I do want to go back to one point that I think was really important, and I heard from several different perspectives we talked about last week, is this written notice in the second gray box, that initial written notice from the agency to why a licensee needs to be evaluated. That it has great value to licensee to be told specifically what it is that needs to be addressed and to protect their due process. It has great value to the doctor to be told so he knows what it is supposed to evaluate and how I know whether or not they're there. And then it has value to TCOL at some point because as we've learned from the F5 problem, if that person quits, or is terminated by the agency, we still have to pursue that process. And that document may be the only thing that we have that identifies clearly what the problem is for us to pursue it from. So I think there, in the focus on how you create the policy and defining that, it's important to recognize that all three of those parties benefit from that particular section.
And that could even be spelled out when it's given to them, that this is why we're doing this. So everyone knows we're not hiding anything.
Correct.
And that's what I was gonna say. If we're saying, if the agency administrator is saying that this person needs a fit for duty evaluation, whether it's medical or psychological, this is gonna be a departmental suspension of some type, or at least desk duty until that criteria is met. So that due process is going to start whenever they brought in and handed that documentation saying, this is why we think you need to have this. And whether it's a use of force that the patrol sergeant comes back and watches the video and went, holy smokes, that was way more than what needed to be happening. And they go back and start looking at some of the other ones and there's a pattern. Okay, that's when that process starts. He's brought in or she's brought in and said, okay, this is why you need to have this evaluation done. So the documentation is already there. They are put on notice. I think at this point, it's just a matter of trying to figure out how strict are we gonna be on these violations? Or is it gonna be up to the department head? Because for me, and I don't wanna speak for the chiefs or the constables, but at the end of the day, that liability for us is on both sides. I don't wanna do anything to jeopardize my relationship with the employee. So we're gonna be as transparent as possible. I don't wanna violate their due process, but I also wanna keep the county out of lawsuits too, if that makes sense. Sure. So we can be extremely rigid with this, or we can leave it up to, other than the obvious, officer-involved shootings or a significant car crash or something like that, where he's gonna be, or she's gonna be out for an extended period of time. But all the other ones, subtle nuances in the middle, is where I think we're gonna get way off in the weeds.
Sheriff, that's a great point. And a department can make a policy as detailed or restrictive as they wish. Again, we're looking at the state minimum standard here.
Correct.
Yeah, I think that's the most important thing, the minimum standard, you know? I agree with you. I don't think we need to be getting so far off into the weeds that we're micromanaging individual departments and agencies.
Yeah.
Which obviously a department can go as far as they want to. Absolutely, that's within their purview.
Part of it is just to remember that TCOL only gets involved if one of two things gets tripped.
Right.
They refuse the department, whatever that looks like, they refuse that, then we get notified, or they accept, go through it and fail. We get notification of a failed fit for duty if they're not willing to go through treatment. If they fail and there's appropriate treatment, we still don't get notified. So there's only two things that trigger our involvement is the regulatory body. So most of this, it literally is between the agency, the employee, and the provider.
Say those two things again. Could you repeat that again? How you said that?
If The sheriff has an employee, asks them to do it, they refuse. I'm not going. Okay, then the obligation now is he would notify T-Cole of the refusal. And then T-Cole, that's the process to where we could ultimately suspend a license until it was resolved, suspend or restrict. The second would be he requests it, the employee acquiesces, goes and does the thing and fails. Okay, so and if the failure, and we always talk about fail as this bright line, because in this policy, it talks about they don't pass, but there's restrictions. In other words, especially with medical. So you have the broken ankle, no, they can't patrol with a broken ankle. Can they work in the evidence locker with one of those things where you scoot around on your, with your cast in the air? So something short of full duty is kind of a midpoint between, nope, they're not approved to go back to work. And most of you probably have an employee in this status right now. So light duty, whatever you call it. So so that would be a failure, but there's a remedy. They're going through treatment, they're doing light duty, whatever. We don't see that. If there's a failure with no remedy and they refuse to do the remedy, then it would come to us. So those are the two.
So while we're here, do we want to go ahead and create those two subcommittees? Is that something we can do?
Sure, absolutely. Maybe even get some volunteers, chief.
So for the next meeting, then we can come back with both sets of information, and have them ready to prove it. I'm gonna nominate Dr. Scheinberg to do the physical. He had to get off to see a patient. He texted me, but I know him very well, so I'll
He was
call
definitely
him.
volunteered then. He got off early.
I'll tell him he's been voluntold.
Sin number one right there.
So is there anybody else that wants to help him out with that?
I'm gonna volunteer to be on the psychological side of it, only because I feel
I had a feeling
that that's a little more
Yeah.
in the weeds than to me, the physical is the physical. If you got your range of motion back in your ankle and you're able to, meet the standards, you're good to go. But I think that where we get in the real gray area is on the psychological side, because I think that that's a very subjective. And I wanna make sure that everybody's got their protections and due processes in place. Sorry, union man in me talking.
I'd be happy to assist with that
So
as
both
well.
y'all,
Volunteer for that one also.
Mhm.
I'll help out the good Dr. Scheinberg.
May get a free heart screening out
I've already done all, I'm a former patient.
there. I'm sorry. Okay, so we have 3 for the psychological, 2 for the physical side. Anybody else want the physical side?
So is it possible we could talk about like what is it that you want those respective subcommittees to do, in the interim, like what responsibilities, what often we need, we're gonna talk about that in here.
Well, I think from what have heard today is we want to come up with guidelines for both
Okay.
sides.
Right.
So we can set our next meeting before we leave. And then in the interim, the committees can work together, phone, Zoom, however you want to do it, and come up with some criteria that hopefully you'll have ready for the next meeting moving forward. Does that sound?
John, is that okay? Is there any issues with opening the meeting?
As long as the subcommittees are set up like they are and bringing it back to the full committee and it'll be fully deliberated, do it all day.
We're just fact gathering and
That's exactly
information
right.
gathering,
That's
and
exactly right.
decisions are
Yeah.
made
For
here.
the larger consideration for the larger group, absolutely.
Yeah, I think with the subcommittees, if we could look at the work product from two pieces. One is the content of the exam, and that's kind of what we went through earlier.
Mm-hmm.
And the second being, what would the examiner need to know from the agency? That what, you know, we talked about the behavior that led to the request or whatever. What would be a logical report from the agency or employee to that examiner to make that determination? So if we could look at it from those two perspectives, that would be helpful.
This is gonna be only post, correct?
Sir?
This is only post-employment, correct? Or is this also gonna be?
This will be for post-employment, fit for duty, absolutely.
Now, will we at some point before March be looking at pre-employment stuff, or is this only post-employment?
I think post-employment certainly, I think, is the proper scope of this particular committee, of the statute.
Okay, gotcha.
Now, there may be some very good recommendations that come out of this process as it relates to absolutely. And I think those would be something that you all could take as a committee to the commissioners. I think that would be fantastic if y'all come up with additional information and reports that y'all want to bring to them to take a look at that. And then they could turn around and impanel you all again, and we could get back in the committee business. No, but I think that's certainly something that y'all can address to the commissioners. But your work product and your main scope of this is gonna be post-employment.
Would it help to have a person from a civil service on both of those boards to help those of us who are non-civil service? So you could give us the perspective of what civil service would do. I don't know if that's how that panned out or not. Two
I'm a
groups.
civil service agency, so we get.
Oh, okay.
So the psychological
I
side.
work with
Yeah, I was gonna say,
What about physical? I think it's just Dr. Scheinberg and the sheriff and myself. I know DPS is not, was not, or is not.
Definitely not.
Might need somebody on the physical. Is there?
yeah, I can help out with that.
Okay, great. Just to give us an idea of what civil service.
Yeah, it's always a good roadmap, because the legislature's already been there and there's a system set up for it. And that's a great thought.
Could someone be in both those camps, physical and psychological, be appointed to kind of guide us to, you know, just establishing meeting time and, you know, setting up teams and all that stuff before we leave here today? Would that be okay?
Probably, we could probably do that between ourselves.
Yeah,
I
I just
think
know
those
the
three-
two subcommittees can talk to one another, and
Yeah.
I think that would probably help both sides.
Next meeting, the holidays, Thanksgiving, and December. I don't know what people's calendars look like, but we're also up against the deadline of March 2024, so.
Chief, for y'all's information, we've got, just the other two committees are set for, sure enough, one is set for December fourth.
The other is November 28th.
Correct.
And
And
we
we have
have,
a-
we have a commission meetings, the 6th and 7th, so that,
What about Tuesday the 5th? Is that hard on you guys right before a commission meeting, or do we have to look to the following week, the 11th, 12th?
I'm good for the 5th or the 11th of December, I think.
Everybody good for the 5th?
Yes.
That's what it sounds like, so.
We'll make it work either way.
Yeah.
Cause I don't
For
know.
the 11th,
sometimes-
but we make the 5th happen.
Sometimes before a commission meeting, you guys are swallowed up trying to
We're
get
gonna be going to
everything
San
ready.
Antonio as well too, so that's,
Okay.
we'll do that on the 6th.
I believe the plan is to be leaving the morning of the 6th.
Okay.
And get to San Antonio for the workshop. We stay overnight, commission meeting next day.
Okay. So we can make it happen.
If we meet on the morning.
Seventh is in San Antonio?
The
We'll
sixth
be-
and the seventh.
Yes, sixth and
Oh,
seventh.
okay.
Yeah.
It's in San Antonio. But we won't be leaving till the sixth, but whatever y'all, whenever y'all can meet, we'll make it happen.
Well, it sounds like the fifth works for everybody. Is it the 1 to afternoon? Is that?
Yeah, that's a good time for me.
I can send out an invite to everybody.
Please. Do we wanna stay here? Is that good? And have the Zoom or the Teams as well, or?
Works fine.
Make it happen.
Perfect. So then, you're open to the public comments. None? I'm not hearing anybody. All right.
That wasn't Jeopardy.
I do have a question. So I know that we're scheduled till 5 and I don't want to press anything with everyone else, but is there more, please don't throw rotten tomatoes at me, but are there more agenda items that we could cover while we're here right now? Cause it's only like 2:45. Or is it just normal to?
So there's-
Again, please.
If it's not on the
Jessica
agenda,
asked me to say that if
Probably maybe be a good time when we adjourn that your subcommittee can get together and discuss further.
There's not more agenda items that we can cover,
Yeah.
but
it's
you
not
can
on the
potentially
agenda. Violate
talk
that.
about whatever agenda items are already on the agenda more.
Well, I'm not gonna go there. I wanna keep.
motion to
my-
reopen.
Also, in the Teams chat for this, we did get, Robert Crawford said the fifth works for him and that he can assist with the subcommittee for the psychological.
How many people are on the psychological?
So
We,
that's
we do have a.
Go ahead.
There are issues, we have to not have a quorum for these subcommittees. And so there's four total now, 4 on each.
There's 3 now, but there
I
would
think
be
it's-
4 with that.
He would make 4.
He would make 4.
On which one?
The
Psychological. And for the physical, there are 4.
Chief Harmon, did you say you were helping out with the psychological?
I said I was helping out with the.
Physical.
Physical, okay,
Physical.
thank you.
So
Okay,
you
that
can't have
clarifies, so
more than
4 and 4.
four.
There,
We have 12, so you go to bust 6.
12, so
33%.
It's fine.
Yeah.
4 is fine.
we're okay.
I've also
Keep it at that.
received, policies from Dallas and Plano and the IACP, psychological standards, and I'll share those out with the group. We'll get those out to you electronically. Thank you. Getting that through. So we'll.
I will get policies from some of the other larger cities.
Okay.
Should I send them to you?
You can send them to
next meeting
us.
So you can disseminate them? I mean, I can share them with my subcommittee, but if you wanna share them with everybody, because the example that I work with on a regular basis is San Antonio. And San Antonio has an extensive psychological services. Not only does the city have its in-house doctors, that the chief is allowed to order people to attend counseling or evaluations. They have the Office of Concern program that the chief is allowed to put them into, which as a component of that requires them to attend psychological counseling or evaluations. So they have a pretty extensive network of mental health, I guess, help within their agency. So
Yeah, if y'all want anything distributed more widely, you can certainly send it to myself or Sarah, either one. And we'll get it out to all the committee members. Certainly do that, be happy to.
Some of the questions that came up on the flow chart were timeframes. I don't know if we wanna discuss timeframes right now as far as.
Let me make a note on the flow chart, and that is an ongoing discussion with SOA as well on how that's all gonna develop. And as we discussed at the last meeting, I foresee a lot of what's on the flow chart being in rule, but obviously you all adopting the general procedures, and we'll have a draft rule how it will work once it comes to TCOL. But we'll get a lot of that, I'll be looking for input for all of you on that as well. We'll be getting all that fleshed out as we move along. That's a great question, though.
But the model policy will cover the timelines for when
Yes.
the reports have to go to TCOL,
Yes.
as well as the, where is it? Yeah, to the notification to the employee.
That's right.
And I think we discussed at the last meeting that there's a practical side to all of this as well, that, you know, if they're going to be required to go see a doctor, doctors will not see you within a few days or a week. Sometimes you can be forced to.
You gotta take
That's
that into
right.
consideration.
So,
Yeah, definitely.
Yeah, certainly all of that will be built in.
Yeah.
Could be a subcommittee.
A timeline subcommittee.
Everybody that's not here today.
There you go, Sheriff.
Does anybody have anything else?
You don't have anything, Chief?
We wanna discuss agenda items for the next meeting.
That's a great question, Cullen.
Chief, if we want, we can start building the agenda for the next meeting. Those items, if,
Sure.
you know, if there are things that the individual members want inserted in that agenda, that would certainly be something we can capture now
Okay.
in preparation.
And I think along those lines, I think we'll add an item on here which may capture a lot of what y'all discussed, is just a subcommittee report.
Yeah.
And we'll put a subcommittee report, and we'll have we've got what, 2 subcommittees?
Correct.
Yes.
We'll put it on there to have a period for reporting from them.
Is there anything anybody else sees that needs to be on the agenda? I think those are probably the 2 most important items.
Just random thinking here. So technically speaking, if we meet once a month, after today, we have 4 meetings, right? Or do we have to be done before March 1st?
We've got to present to the commissioners late February.
Late February. So that would be, if we're meeting once a month, we have 3 meetings
December.
if we meet once a month. Just, you know, I don't know how this works, but is that enough time to fish out what we need to fish
I
out?
think that depends on us.
It's gonna have to be enough time, right?
I mean, in
Three
January,
things. I mean, you've got the physical subcommittee, the psychological subcommittee, and the rules to be put in place. So I mean, that's 3 large topics that need to be finished.
But I think with the subcommittees, though, we'll be working, you know, between now and the next meeting. So working amongst ourselves in the subcommittees, we should be able to provide more polished direction or suggestions at the next 2 meetings, so that hopefully in January, we're making some decisions or recommendations to
Kind
them.
of fine tuning things.
Yeah.
I think the December meeting will kind of give us a
Okay.
guideline and a roadmap to see where we're at. We may have to meet twice in January and
Do it by video conferencing, so I mean, that's certainly possible
Yeah.
too. That affords you some more meetings. The thing to remember, just for notice requirements, we've got to do them 7 plus 8 days out essentially every time we do the notice. So if you have one meeting, you're like, we've got to do a follow-up one, you're gonna have to wait 8 days if we haven't registered it. So that's something to think about too. But I do think it's a great step forward, getting the subcommittees in the focus, and we're economy and focus of purpose is where you are at now. That's gonna make a big difference. And kind of understanding the scope of what it is, the undertaking you have. I certainly don't anticipate a 50-page document being produced at the end of this. Again, we're talking about minimum standards where none exist in many places in the state of Texas right now. That's a step forward from where it was. So any positive momentum and movement that's made by this committee will be leaps and bounds ahead of where it is now.
I think if you're comfortable collectively with using, say, the Lexipol or Dallas or one of these models, I think the subcommittees can start the
Yes.
wordsmithing and then bring it back to the whole for
Right.
consensus. So if
Yeah, I
you
don't
want
think we have to
start-
reinvent the wheel.
Absolutely
The
not.
information is out there.
This stuff is here. This stuff is out
It's just-
there. Yes, absolutely.
Glean what fits best out of each one of them.
Right.
What's most important, and that may be what you all come down to, what criteria are most important?
And we've got to add the new legal component into the policy. When does this have to go to TCOL stuff is the thing that's missing from all of them. And so that will be new work.
So I guess two questions out of these, we got these two subcommittees, we talk about deadlines, the SOA hearing and that process, so it's kind of the third major section that we're dealing with. Are there any other major issues that you see that we should be dealing with at this point?
I think from our perspective, I think y'all have scoped it pretty well. I think with the subcommittees you have and kind of the rulemaking on our side, which obviously we're gonna start drafting that up and send it all to you to make sure that's kind of the other piece to the puzzle here. But I think that's, I think y'all have got your eyes on the prize, and that's, it's gonna be plenty for all of us between now and then.
And my second question is the presentation to TCOL, what role do we have in that, drafting the document, drafting a report, what does that look like?
This is the way we see it happening for all the subcommittees. Bring it, send in the final version to us. We'll have kind of a unified format and presentation for all three of the committees. Obviously, the substance will be whatever you send us. We'll change the formatting, put the cover on from each committee, all those things like that. With the misconduct committee, Chief Standridge he says he plans on being here to present it to the commissioners in February. So that's certainly one option. It could be any of you want, if any of you want to, or we staff could do it on your behalf, however you want to do it. But I just give you an example of that committee, what they're wanting to do.
Chief Harmon, this is Sean Kennington. Can you hear me?
I can.
Okay, first I wanted to thank you for chairing the meeting in my absence, and sorry I couldn't be there. And I know it seems overwhelming or listening, but I think part of it is we definitely are trying to come up with a minimal basic policy. And we keep trying to probably go into the weeds more than we need to when we're talking about different things as far as doctors. So I think if we, these subcommittees, when they go to looking at, the employee fit for duty, that's basically your fit for duty if you're able to perform the essential job functions of the duty. So what we've talked about is getting that information, what the job requires for the psychological or the medical doctor for the physical. Like I said, I think that will give the right direction to the doctors without us trying to determine what doctors are fit to or qualified to do this. And I'm speaking from a rural. We're talking about big cities, but for the rural, and I know Sheriff Valdez, also in a kind of rural area, we travel an hour to even find a psychologist or someone to take care of that. So to make it more restrictive as far as who could do it, I don't think would be advantageous. And then also, but like I said, giving that information out, I think allows us to at least have the doctors know what we're needing and what would be required of them. And I think open it up for the rural areas a little bit more. But I think that we can definitely get this done by February as long as we don't try to delve into more than what we're actually tasked to do. And it's not that it's simple, but I think we can put together a model policy that just gives the basics. And then if there's departments that want to go above and beyond that, then that would be great. But that's all just from what I was picking up from, I haven't said anything during the meeting, but I don't want to get into the trying to decide if a doctor's fit for duty and can handle the tasks. I think we just give them the information and let them do what they're able to do, so.
I have a question based on something the constable just raised, and a personal life experience. I complained about the 25-minute phone interview, but I know a lot of telemed now is going on. Is that something that we need to address? How they conduct the interview in person or by telemed? Because as the constable said, he and Sheriff Valdez are an hour plus away from any reasonable play, plus you're asking the officer or deputy to travel. Is that something that we address, or is that something that a department addresses?
Colin, why don't you roll out agency policy in regards to?
I mean, our policy with the psychological exam had always been face-to-face unless you got a waiver, and then COVID hit. And everything went to telemed. Now, the good news is there was a whole bunch of ramping up, and there's a whole bunch more providers that can do telemedicine reliably. If you look across the state, a bunch of state agencies went the same way, and so our commissioners ultimately said, we need to accept telemedicine as a means by which, specifically the psychological exam. You can't do a drug screen, which is an L2 component, remotely. Yeah, I'll mail you the jar. But from the short answer is yes. We TCOL recognize telemedicine as a viable means to do a psychological examination. If you have any feedback on that, Doc, but it was we were driven there based on what happened, during the shutdown. But we didn't see any ill effects, and it did. A lot of people who had waivers. The other thing that Texas does is restrict it to Texas licensees. So when COVID hit, or even as COVID started to let up, people in Texas couldn't get physically in front of a doctor who had an open office. But they could do it in Oklahoma. We can't let them use it because the statute states they have to be licensed to practice in Texas. And so short answer is we recognize telemedicine for the psychological exam.
The thing I'd like to add to that, I think I've reminded all of our committees that we struggle with every day is there is no one size fits all. It just does not exist. And everything we do, the intention of helping a larger agency works against a smaller, every time we try to help a smaller agency, we work against a larger. We're always trying to find that balance. When you talk about whether or not someone is psychologically fit for a job, where they have to make a split-second decision about taking another person's life, whether or not they have to drive an hour to do that is not something that, to me, should weigh into that decision. But we will have to find a balance on all of these things that will work for all of the agencies, because we serve so many different types of agencies under so many different types of circumstances. But like you talked about, that's part of the challenge for the doctor. That's what doctors have talked to me about, where they might be fit to work in a one-man sheriff's department would be very different than if they were working at the Houston Police Department. So you're gonna have to find a way to incorporate that. We struggle with it every day.
The only thing I would mention, like for post-employment evaluation, giving a legitimate standardized test, like for example, there's a MMPI-3 police candidate test, or PAI police candidate test, or public safety officer test. If that can be done, at least the MMPI-3 could be done remotely, but it has to be proctored. And then you have to ask who would do that proctoring. So I just want to throw that out there.
Yeah, and again, I don't want to get too far out there on the end of the branch about, I think that, well, I keep going back to my 25-minute phone interview. I also don't know if do we really need a 45, 50-minute written exam followed by, can a doctor talk to you for an hour and a half in an office visit and determine, based on criteria that, they're okay with signing off on the officer being acceptable, be passing. I don't wanna create a standard or a hurdle that is next to impossible to get over. I get the concerns of the life or death situations that were just alluded to. But having been in law enforcement for 35 years, or in and around law enforcement for 35 years, written exams and, there's a limit to how far you can really look at somebody on paper and make a determination as to whether or not, sometimes just sitting down with them for an hour and getting some really good insight. I don't pretend to practice medicine, but I certainly don't want to recreate the wheel as we've been talking about.
And that's my biggest concern is that, like I said, I don't know that that's our task is to tell a doctor on either side of how long they should visit or what they should do. That's their expertise. I think we just need to make sure as a committee, we give the information out of what we need, what we're looking for. And then if they, I don't, like I said, I'm not either side. I don't know either profession, but if it takes 30 minutes on one and 2 hours on someone else, then that's up to the doctor, in my opinion, to do his job. And based on what we give them, but I don't know that we can get into the weeds of telling them how long they have to visit or what they need to do, in my opinion, as far as this committee, but I could be wrong.
Doc, would they have to take a written test?
I'm sorry?
Would they have to take a written test?
There's no way that I would do a post-employment evaluation without having a test for pathology, or two of them, or at least one test for pathology and one test for personality, 16PF, for example, and a face-to-face interview. Now, the telemedicine situation, that could be altered a little bit, but and then what I'd add to that is the background information, what led up to
Correct,
this.
that's why I was asking.
And the, I like the idea of, okay, there's minimum standards, test given, face-to-face interview, but then this other piece where we might be looking at criteria like these, A through F type of thing, that we don't want that violated, because that's probably what led to, at least from a psychological perspective, led to them having the fitness for duty evaluation. Anyhow, that's gonna set a good minimum standard, and then the doctor can decide themselves. But I think you're limiting yourself because, there's no instrument out there that's gonna perfectly evaluate someone. But, cause some personality inventories, they show no psychological pathology, but they're not fit for duty based upon what you find out during that clinical interview. And so I would not at all be in favor of eliminating a formal written evaluation, if that's what you're talking about, like a standardized test that has gone through some significant normalization with the police population.
But to the constable's point though, I don't think we should be telling the doctors who are gonna be conducting these examinations how to conduct them. I think we may have to recommend that you pointed to the two, personality and pathological, how they arrive at those decisions though.
Yeah.
Within their practice of medicine is on them. I don't think that we as a committee should be telling them, well, you need to do this, this, and this in order for it to be a certified or qualified exam. I think that just saying, hey, you need to look at these two areas, how you do that should be up to the doctor.
Yeah, I'd agree with that.
Thank you.
Maybe up to the agency. you know, agency can make it more restrictive.
Yeah,
Their own
right.
qualifications on it.
Absolutely.
So we're minimum.
Yeah, these are only
Yeah.
minimum
Minimum
standards.
standards.
You can go above and
Yeah,
beyond.
the agency can always give more, just not less.
We're ready to adjourn?
Do you have anything further, Chief?
I think we have 2 more hours now.
Sure. Feel free to sit here, Doc.
It's a nice view out there. Watch it rain on
All right, well,
So
we'll call
move.
it. 15:07.
Thank you.